So when it comes to credit reporting, a couple things that I get a lot of questions about. Number one, what about charge-off? What does that mean? Does that mean that you no longer owe the debt? Can they report a charge-off only 1 month, or can it be month after month after month? And then second, what about a bankruptcy discharge? And particularly when you put those two things together, what if you have a charge-off and it's reporting month after month after month, and then you file bankruptcy and you get a discharge, and then it continues to report a charge-off after the bankruptcy? Well, that's what we'll look at in this case. Came out March 15, 2022, Otto versus TransUnion, but really for our purposes, it's against Chase Bank. So let's take a look and see what we've got going on here. So we have Chase Bank has filed a partial motion to dismiss for failure to state a claim. That just means they're saying we're not trying to throw out the whole complaint, but we want a good portion of the complaint thrown out because there's no way, even believing what the plaintiff says, what the consumer says, there's no way the plaintiff consumer can win. And the judge says, well, I'm going to grant part of the motion, Chase, and I'm going to deny part of the motion. So let's look at the background here. So we have a Chapter 13 bankruptcy was filed. We have a Chase account was included. And then there was a bankruptcy discharge March of 2020. So then in November of 2020, the plaintiff consumer ordered a 3-bureau credit report from Fcra. Now, this is not my favorite way to do it. I prefer to go directly to each bureau so we don't have an issue with, like in this example, pulling from Fcra, and then we say, well, TransUnion, here's what you say. And they go, no, that's not what we said. That's what Fcra said that we said, but that's actually inaccurate. So I just like to take that argument away. It's really a big problem when you're doing it with like a credit monitoring or a tri-merge report. But even when you go to one of the bureaus and get all three, I don't think that's as good as going to each bureau, and you can do that through annualcreditreport.com. So what happens is the plaintiff sees some things that the plaintiff believes is incorrect, and some dispute letters are mailed, and then the plaintiff says those dispute letters were forwarded to Chase as the data furnisher. The significance of this, and the judge won't come back and mention this because it's not at issue, is you can send all letters in the world you want to Chase, for example, and you can't sue Chase under the Fair Credit Reporting Act for incorrect credit reporting unless one of the credit bureaus notifies Chase. And you can send all the letters in the world to the credit bureaus, and if they don't forward that letter, that information, that dispute to the furnisher, such as Chase, then you can't sue Chase under the Fair Credit Reporting Act. So let's go on and see what we've got here. So the allegations are, and we'll come back to these in a moment, reported late payment history during the bankruptcy. And actually, that part Chase does not challenge. And then post-discharge on his account. So post meaning after. So after the discharge, the plaintiff is saying, hey, Chase, you reported late payments after the discharge. Well, kind of hard to be late when you don't owe anything. And the Chase account's being reported as a charge-off more than once. In other words, month after month after month, which is inaccurate. And the plaintiff says charge-off is really a one-time event, and a single debt cannot be charged off repeatedly. So court says, well, let's look and see here, what a charge-off is. That means creditors change the outstanding debt from a receivable to a loss in its own accounting books. And so we have all these months where it was reported even May of 2020. And if you remember, the bankruptcy discharge happened in March of 2020. So here we have April 2020 and May of 2020. And depending on how you look at it, even March of 2020 would have been after the discharge still being reported as a charge-off. And the plaintiff says that damaged my credit score. All right, so let's look and see what we've got here. We've got two major sections under the Fcra. The first section only has to do with the credit bureaus, Equifax, Experian, TransUnion. So that's section 1681I. Think of I for investigation. And that says, hey, I notified the credit bureaus. They had to do an investigation, including notifying the furnisher, and they did a lousy investigation that harmed me, and I'm suing them. And then under 1681 S2B, which is saying, hey, Chase, you were notified by the credit bureaus. They have to be notified by the credit bureaus. And you, Chase, the furnisher, did a lousy investigation. And now I'm suing you. All right, so what is it, again, that we're being sued for? Chase says, or the plaintiff says, Chase inaccurately reported the status by reporting it charged off multiple consecutive months. And the plaintiff says that violates the Fcra and industry standards. And Chase says, no, this is allowable to do this. Okay. And so what's the purpose of the Fcra? It's to ensure fair and accurate credit reporting, promote efficiency in the banking system, and protect consumer privacy. So how does it do that? Well, we've got some duties or obligations on credit reporting agencies and on furnishers of credit information. So what's the requirement on a furnisher? Well, there's one that sounds great, and it is great, you just can't sue on it. So a furnisher cannot report any information relating to a consumer to any consumer reporting agency if the furnisher knows or has reasonable cause to believe the information is inaccurate. Unfortunately, they can go, yep, we knew it was false, we did anyway, we don't care, we think it's hilarious, and there's nothing you can do about that. Okay. But if you dispute the reported information to the credit bureaus, and then they notify the furnisher, now the furnisher must conduct a reasonable investigation and report back to the credit bureaus. And so when can a consumer sue? You have a private right of action, which means you can sue under the Fcra against a furnisher who, after receiving notice of a dispute, fails to conduct a reasonable investigation or continues to provide inaccurate information following the investigation. And here the plaintiff says this is just flatly wrong to report month after month after month of charge-off. And so now the court's going to get into this and start analyzing what other judges have said and then decide what this particular judge believes. So charge-off is a term of art for credit providers understood as writing off a debt as a loss because payment is unlikely. So here we have another quote. So they're required to charge off delinquent accounts after 180 days, or else their balance sheets would misleadingly reflect accounts as assets that have little chance of achieving their full valuation. So I've used this example before. Imagine that I have a company, then you want to buy the company, and I'm going to sell it to you for $100,000. And it has $1 million worth of assets, 0 debts. You go, well, that's fantastic. You're going to pay $100,000. It's worth $1 million. You sell it, the assets for $1 million, or you collect it, whatever it is, and now you made $900,000. Well, here's the little problem that I forgot to tell you. The accounts receivable, that's actually just one account, and it was due in 1917, so 105 years ago. Well, it's unlikely you're going to collect. And so that would be misleading from an accounting standpoint for me to list that as an asset. Like, hey, I expect to collect $1 million on a 105-year-old debt. No, that's just wrong. Okay. And so accounting rules would require me to not list that as an asset. So that's what charge-off is. It has nothing to do with whether we still owe the debt or not. It's just an accounting function. So let's see what the Fcra says. You can retain a charge-off notation for a debt for up to 7 years. Here's a judge in a recent case says, consumer's debt does not simply disappear when a creditor charges off her debt. Here's another one. Charging off a debt does not diminish the legal right of the original creditor to collect the full amount of the debt. So then the court says, courts have routinely rejected the plaintiff's argument that reporting recurring charge-offs is inaccurate or misleading. And so just here's a quote we'll look at. No evidence that reporting a charge-off on a single trade line in consecutive months would be misleading. Here's a case called Shaw. It says nothing to indicate that anyone would believe there's been more than one charge-off because, as all parties agree, there's only one charge-off event. And then the Ninth Circuit, which is one of the Court of Appeals that is over the federal trial courts, federal district court, says the report of multiple charge-offs does not support a plausible claim. That's the test under a motion to dismiss. Because plaintiff has failed to plead that anyone would believe that the account had been charged off more than once. It's undisputed an account can only be charged off once. All right. So the court says, I'm joining this growing consensus that repeatedly reporting a delinquent account as charged off is not inaccurate within the meaning of the Fcra. But here's a caveat. Remember, the debt was discharged in bankruptcy in March of 2020, but Chase continued to report it as charged off in April and May of 2020. So let's look back at this. And this is citing from a very good, very famous 11th Circuit case. 11th Circuit is where I practice, which the 11th Circuit Court of Appeals is over Alabama, Georgia, and Florida federal courts. It says, although a charged-off debt is treated as a loss for purposes of accounting, the debt is not forgiven and creditors can still pursue it. So here's the quote. Charging off a debt does not diminish the legal right of the original creditor to collect the full amount of the debt. Here's another one. This is from California. Charge-off debt's legally valid, remains enforceable. And court says successive reports of charge-off debt will not support a claim, but this ruling does not reach the post-discharge or after discharge period from April to May of 2020 when plaintiff alleges Chase continued to report the debt as charged off. So here's a case out of California. We will look at this quote. Actually, two quotes here. Legal status of the debt does not change until the debtor is discharged from bankruptcy. And it is not misleading or inaccurate to report delinquent debt during the pendency of the bankruptcy proceeding, but before the discharge. So when we file bankruptcy, now there are certain requirements about can they continue to update our credit report. We're not going to get into that today, but they certainly can leave stuff on there and say currently the account is charged off, because we don't know if we're getting a bankruptcy discharge until we get it. But once we get that discharge, now going forward, it's going to have to change here. So let's look at this California case. Plaintiff's debt was discharged in bankruptcy 2015. It was not just obviously incorrect or misleading for a creditor to list a charge off in December 2014 and January 2015. So the point is, once this person in this California case got the discharge in 2015, you can't report a charge off in 2015, and certainly not in February 2015 and then March 2015 and April. But prior to that, you can, because that was correct. So the court says that granting Chase's motion only to the extent it moves against plaintiff's claims as inaccurate or misleading to successively report a debt as charged off, but not granting it for that time period after the bankruptcy discharge. And so here we have the idea of industry standard. So oftentimes this is called Metro 2. Metro 2 is just, think of it sort of like the language that furnishers and credit bureaus communicate in. Because the bureaus don't want 10,000 different furnishers having 10,000 different ways of reporting the data. So they say, here's the format you must use. It would sort of be like a PDF document, right? A PDF, whether you're on a Mac, a Windows, a Chromebook, iPhone, Android phone, whatever device you're on, you can open up a PDF. It's just a standard language. That's really what Metro 2 is. And then there's a book that sort of explains how you follow and how you use this sort of standard of communication. Well, a lot of times people bring lawsuits and say, well, you violated Metro 2 standards. Some courts accept that, some don't. You really have to do a good job of proving that and proving why that's important. So here the judge says claims been rejected by district courts around the country. Holding industry standards such as Metro 2 guidelines are not binding, violate them does not amount to a per se Fcra violation, which is a true statement. Just because Metro 2 has been violated does not mean the Fair Credit Reporting Act has been violated, but it certainly can be evidence and it can be helpful. And you'll notice this is a case here, this Bank of America case from what, 8, 9 years ago, holding that without more. So that's the key. You have to have more. Holding that deviation from the Metro 2 guidelines does not make a report inaccurate or incomplete. And so that's the case. I wanted you to see this again for two reasons. One, what about a charge off month after month after month? This court is taking the position, and a lot of other courts take the position, that that is 100% fine. But once you have that bankruptcy discharge, to report after the bankruptcy discharge that you were late, or you have a charge off, or you owe money, all of that, I'm talking about after the discharge, would be wrong. And if you dispute that, it doesn't get fixed, then you sue on that. So I hope you found this helpful, and just let me know your questions and comments. And again, this is Jeffrey Scott Otto versus TransUnion. This is in the District Court of Oregon, Eugene Division, March 15, 2022. And it is Judge Ann Aiken. Hopefully I'm saying her name correctly there. A very good opinion, and hope that this was of some value to you. And I'll talk to you guys later. Okay, have a good one. Bye-bye.